Hi, everyone. My name is Michelle Lucas, and I'm the directing attorney of the Tenant Law Center. The Tenant Law Center is a program of Catholic Community Services, and we are a legal services office that provides free legal representation and assistance to low-income renters in the city of Seattle who are facing eviction, housing subsidy termination, or other housing instability issues. I'm here today as part of Solid Ground and the Dispute Resolution Center's webinar on how to prepare for the end of the eviction moratorium. And I wanted to take this opportunity to answer a few frequently asked questions that we've been getting while we've been doing webinars over the past few weeks. One of the first issues that I want to take up is the new right to counsel in eviction cases in Washington state. We're really excited about this law, and because of the number of people who are having trouble paying their rent right now because of the pandemic. One thing to keep in mind is that not all renters in Washington are going to qualify for this assistance. There is a requirement that a renter have a low income in order to qualify. The statute uses the word indigency, which is just a legal term to say that a family or a household has low income. And it defines indigency to mean someone who is receiving certain kinds of public assistance. Those kinds of public assistance could include TANF, or temporary assistance for needy families, age, blind, and disabled benefits, medical care, veteran benefits that are related to being low income, food stamps, refugee resettlement benefits, Medicaid, or supplemental security income. People can still qualify if they don't receive those benefits if their income is 200% or less of the federal poverty level. I don't have those numbers ready for you because it's going to differ by family size. But if you do receive an eviction notice from your landlord, there should be information on that notice about a phone number that you can call to be screened to see if you qualify for free rental assistance. And that number will also be able to connect you with the appropriate provider. There's a similar law that has passed in the city of Seattle. So if you live in the city of Seattle, they have their own right to counsel law for folks who are facing evictions. The definition for indigency in Seattle is a little bit different, but people still technically need to qualify under that definition in order to be able to have access to a free attorney. In Seattle, it's much more expansive and a lot more people are going to end up qualifying. And all you have to do in Seattle is be unable to pay for representation at any stage of the eviction process. So the requirements aren't going to be quite as stringent as they are statewide. So I think that this means that in Seattle, more people will qualify for free legal representation in eviction cases than they do across the state in general. The next question is about the mediation process, and specifically a question about the Dispute Resolution Center. So does the Dispute Resolution Center deal with evictions based on something other than unpaid rent? Marilyn Littlejohn from the Dispute Resolution Center did provide her presentation earlier, but I can address this question as well. I should say that I will be speaking solely based on what the King County Dispute Resolution Center can provide. There are other dispute resolution centers. If you're not in King County, there are probably other dispute resolution centers in your area, and you'll be able to access that information by calling 211 to find out who you should be contacting. As far as the King County Dispute Resolution Center goes, they do assist tenants or deal with other legal issues for mediation, including lease violations, or if there are behavioral reasons that somebody is being asked to leave their apartment. They also deal with deposit issues, if there are disputes about damages. And the one thing that I should mention is that if someone is accessing services at the Dispute Resolution Center as part of the eviction resolution program, so if it is a dispute based on unpaid rent, that mediation is going to be free of charge. If there are other issues that they're facing and their housing stability is at risk or they're at risk of losing their housing, then that mediation will also be free of charge. For other kinds of issues, it is a low cost but sliding scale basis. And so not all services are free, but if you are being evicted from your home, there is no cost to mediation services, especially because mediation is going to be required under the eviction resolution program in King County. The next question is there an outline of information lawyers would want or need when contacting them to make the best use of free consultation time? There's a lot of information that could be helpful to have ready if you're going to be meeting with a lawyer. And one of the things that I can say that can be really difficult is when people just come in with a big stack of paperwork and you have to spend a lot of time sorting through it and trying to figure out what's going on. So the best thing I can say is kind of come in, be organized, have some basic information about your tenancy ready. And it might be stuff that you already know, but having it ready, written down, prepared could be really helpful to make the best use of time when you're talking to an attorney. If you could have your address, your move-in date, your landlord's information, having that ready can be really helpful. Another thing that's really important is to have copies of any paperwork that you've received regarding an eviction or any other paperwork that you may have received from your landlord about the issue that you're coming in with. Um, it could also have come from your landlord's attorney, or it could be other related paperwork if you think it is pertinent to the possibility of losing your housing. If you have notices, so an example might be a 14-day notice to pay rent or vacate. Bringing that with you would be really important. It would be really important to have any follow-up documents that you might receive. You might have something called a summons and complaint. That's another form in the eviction process. If you had that, you want to make sure you have all of that paperwork for the attorney. The other thing that would be good would be to know what dates you received that paperwork. The dates really matter when we're trying to figure out how soon you need to get back to your landlord and how soon you need to respond to things. If you do have a lease, then have a copy of your lease as well. Even if you're a month-to-month tenant and you have a lease, but it's expired now, so you don't think it matters, it's still really important to bring that because unless you and your landlord came to some sort of different agreement, then the terms of that lease still govern your tenancy. So even if it's expired, if there was no separate agreement that was made, then that's still the terms of your tenancy in that lease. So even if it's old, if you have a copy of it, bring it. That can be really helpful. Having an idea of how much money you owe can be helpful also. And having looked at your budget beforehand to consider how much you could pay in a repayment plan, if anything, while you would still be able to live comfortably, or at least take care of the things and cover your necessary monthly expenses. You still want to be able to. You don't want to agree to a repayment plan that's something that you can't afford. So having an idea of what your financial situation is going into this is really important. I totally understand that it could still be very unclear. I know that things are starting to open back up, but I don't think that we've seen a bounce back. There are still people who are out of work. We're still very much in this pandemic. So you might not be in the best financial place right now, but the important thing is to be realistic when thinking about what your finances are and to really come up with an amount that you think is reasonable that you would be able to commit to if you need to be on a repayment plan for unpaid rent. The next question is, how long may it take before a landlord can call the police to remove a person for not agreeing to payment or mediation? This is a really good question, and I think this is something that we hear about often. The key thing to keep in mind is that right now, the moratorium is scheduled to end on June 30th, 2021. If you are behind on your rent, when July 1st rolls around, your landlord will not be able to just remove you from your apartment. There is a legal process that needs to be followed. And if you live in King County or a few other counties across the state that are taking part in the eviction resolution pilot program, then there are even more steps that need to be followed. So the first thing that will happen if the moratorium ends and you're still behind on your rent is your landlord will need to send you a 14-day pay or vacate notice. It is very possible that before the moratorium ends, you'll have gotten one that says 14 days, and that talks about how much money you owe. This is one of the voluntary notices as of the eviction resolution program that was covered earlier in this presentation. If you receive it before the end of the moratorium, then you don't need to respond directly to that. You have the option to. You can engage in the mediation process at that point. But if you haven't engaged at that point, when you get the 14-day pay or vacate notice after the moratorium ends, that's when you do need to respond. And you should reach out to the Dispute Resolution Center, and that contact information will be on your notice. That notice is very literal. You have 14 days to try and pay your rent. One thing that it doesn't mean is that if you can't pay, you do not need to vacate. You have the opportunity to work to try to come to a repayment plan. It's important that you get in contact with the Dispute Resolution Center, though, so that they're able to work with you to try and schedule some sort of mediation and some sort of conversation with your landlord. If 14 days go by and you are actively working with the mediation program or and actively involved with your landlord, then that process can keep going and you don't need to leave after 14 days is up. If for some reason mediation fails, if you are unable to come to an agreement, and that's entirely possible, there's no guarantee with mediation that an agreement will be reached, and no one's required to come to an agreement. So if the parties aren't able to come to an agreement, then the legal process of the eviction is able to move forward. In that situation, the next piece will be receiving additional paperwork from your landlord that's called a summons and complaint. So this paperwork is going to have information on it that's going to say on the front that this is a lawsuit to evict you. This is kind of what starts the ball rolling as far as the process kind of going into the court system now. So pay really close attention to what the summons and complaint says. It's going to have a date on it by which you have to respond. It's usually 7 days, but make sure that you pay attention to what the notice itself says and make sure that you follow the instructions to respond by that date. If you don't respond by that date, it is possible that your landlord could try to go to court to get a judgment against you for not responding, because by not putting your name out there and not filing what you need to say that you are contesting this, then the court might be able to enter a default judgment against you. So it's important to respond by that date. Once that date has passed and you have responded, there's still very much a possibility that you could be working on trying to negotiate a plan. But the next step is that the landlord needs to set a hearing date. And that would be the date when you go into court and your landlord will be there also, and you get to present to a judge about why you don't think you should be evicted. It could be why you don't think the landlord's repayment plan was reasonable, or what kinds of circumstances are keeping you from being able to make those repayment plans. And the judge will be able to make a decision on your case. I've talked about a lot of the process, but the big thing to keep in mind is that the 14-day notice won't get served until after the moratorium ends. So the earliest would be the beginning of July, July 1st. So that's 14 days. And then there's about 7 days after that. The landlord then needs to serve the summons and complaint. And you still have a few days there to respond. So nothing will happen in that time frame except you can respond, you can keep on negotiating, but things won't move forward until that response date. Not until after that response date will the landlord schedule an eviction hearing. And then you'll get another notice in the mail, and you'll have at least 5 days notice. So with the 14-day notice, be like approximately 7 days to respond to the summons and complaint, and then 5 days notice for the hearing. We're looking at least 3 weeks. And one thing to keep in mind is that the process doesn't always move that fast. That doesn't always move that fast. That's about as fast as it could possibly move if they were really, really pushing things. We expect to see a lot of these cases. We expect to have a lot of things coming through. The dispute resolution centers will be busy. The courts will be busy. And I think the big takeaway is that it's not going to be immediate. If you're unpaid on your rent, when the moratorium ends, you don't have to get out right away. At the eviction hearing, the judge will make a decision about whether you get to retain your housing, whether the landlord gets to take the property back. In some situations, it could possibly be set for additional fact finding, but the bottom line is that it'll take at the very least 3 weeks to get to that date. And in that whole period of time, you'll be able to stay in your housing. Even after that hearing, the judge then orders what's called the writ of restitution. And the writ of restitution is the order that will actually allow the sheriff to come and have you leave your home. And it still even takes, it's not immediate. So the sheriff will have to come and serve that. So you usually still have at least a few days, if not more, after the hearing to vacate. And there will be a date on that for when it's supposed to go into effect. One thing to remember is during that process, your landlord's not allowed to lock you out. Illegal lockouts are just also known as self-help evictions. They have to follow that legal process. They can't remove you from the home before a judge issues that order. And so if your landlord does try to lock you out before that happens, then make sure you reach out for legal assistance, or if you feel comfortable, you can also try calling law enforcement to see if they can help you get back into your home. The last question is it legal for landlords to impose a late fee for a late planned monthly payment? This question is about repayment plans under the new law 5160 that are required for folks who are behind on their rent coming out of the eviction moratorium. The payment plan itself can only be for rent, and it's not allowed to include repayment for late fees that have been accrued during the moratorium because people haven't been allowed to charge late fees during the moratorium. The new law does not say whether it's okay for landlords to charge late fees if your payment under the repayment plan is late. It doesn't provide any specific information about that, but it doesn't clearly say that landlords are not allowed to do that. The one thing I would tell folks to consider is you have an opportunity to negotiate that payment plan. It is meant to be an agreement. It's meant to be something that works for both you and your landlord. It should you should take into account your particular financial circumstances about what can be paid, and your landlord should be taking that into account as well. And just remember not to agree to something that you don't think you'll be able to stick to. And I understand that things come up. We're all susceptible to having unexpected things happen to our income, kind of like the pandemic. Nobody would have imagined that it would have gone as far as it did, but there doesn't appear to be a prohibition against landlords adding a late fee if repayment plan payments are late. And so if something like that gets included in your repayment plan, then make sure that it's something that you think that you would reasonably be able to handle and that doesn't seem that's too out of control. I hope that that's helpful. And thank you so much for attending this presentation.